Good afternoon, everyone. Welcome to the webinar called Work Visa Options After OPT. My name is Fuji Whittenburg, and I'll be conducting the webinar today. I just wanted to give you some information about our offices. We have an office here in Los Angeles, in Santa Monica, and we have another office in New York. So if you are local, feel free to contact our office, and we can schedule a consultation. If you'd like, you can also follow us on Facebook, follow us on Twitter, or you can sign up through our website to receive our newsletters, which are pretty informative. We try and keep everyone up to date in terms of recent immigration updates. And just a side note, obviously I have to say this is just a presentation. It's, we're offering general information for those of you who are in F-1 status, so each person's situation is really unique, and so I urge you to contact either myself or another immigration attorney about your specific questions. You can also email me. My email address is here, fwhittenberg@wolfsdorf.com, after the webinar, and I'm happy to answer your questions. And I think there's also a question function here on the webinar. You can go ahead and type your questions. If there's time at the end, I'll try to answer a few questions. If not, what I do is I print them out, and I can email you guys back individually, or again, feel free to email me later. Okay, with that out of the way, we can go ahead and get started. Just one quick update I wanted to share with you guys, paperless I-94 cards. So for everyone out there who has paper I-94 cards stapled into your passport, that's something that's no longer going to exist. It's going to be, the paperless process is going to be implemented nationwide in a couple of weeks on May 21st. It's starting here at LAX on May 14th. And so basically what's going to happen, instead of completing the I-94 card, that white piece of paper at the airport or on your flight, CBP is going to be collecting, going to be collecting travelers' information in advance by accessing the flight manifest, basically, or the electronic travel information. It's only going to be implemented at airports and seaports. So if you're, coming through the land border ports, they're still going to have paper I-94 cards, and this is going to be interesting, so we'll see how it's implemented. But one thing, everyone should be aware of is that, moving forward, if you are traveling sometime this summer or in the future, you're going to basically have to, you can access your I-94 information. So your passport will actually be stamped, and then you'll be able to access this information online, and you can actually print out an print out the electronic version, and you'll need that in terms of, employment verification or I-9 records or, records for your school and everything else. So this is brand new, and it'll be really interesting about how this all works out, and hopefully the kinks will be worked out quickly. We'll see. But I think hopefully it'll make, make going through customs a little bit quicker. Okay, so for those of you, I'm assuming everyone who's listening is either currently enrolled in school, you're in F-1 status, you have graduated recently, or you are graduating. So most of you are already aware of CPT and OPT employment. And, obviously your school, I'm sure a lot of schools tend to have, kind of their own meetings or kind of events scheduled to go over the specifics as they relate to the school. But I just wanted to touch on them. If you do need to work, a lot of people do. You can work on campus. On-campus employment is okay, 20 hours a week. There's also CPT, curricular practical training, so it's like a work study or an internship while you're in school. You can do that. It's called CPT, and it has to be part of a curriculum, so it has to be approved, either through your degree program or through the school. And then there's OPT, which is optional practical training, which is full-time employment, and most people, the most common way to use it is after you graduate, you get 1 year of OPT. It's an employment, it's an employment authorization card that you get. It's an EAD. You have to apply for it. There's a simple form. It's an I-765. Usually the school will help you complete it, or again, they tend to have their own little seminars on how to do it, when to do it. So I would talk to them. You don't need an attorney or anything, and I urge you guys to make sure that you apply for it. It's the only time you're going to receive any sort of cheap and easy work authorization for 1 year. And then just another note, a lot of times people don't do this, but you have to make sure your I-20 is also endorsed for employment, because your employer, whoever you're going to work for, they need to see that along with the EAD, or to make sure you're authorized. For those of you who are in the STEM fields, science, technology, engineering, or math, there is, so in addition to the 12 months you get, the 1 year everyone gets by graduating with a degree from a U.S. university, bachelor's, master's, doctorate, or higher. There you can also get a 17-month extension. So then that would be a total of 29 months of work authorization that you can get. It only applies to the STEM degrees. You can go to check the website I gave here. It's ICE that issued this, kind of designated list. So you can go and check to see if your degree is there. The job that you have while on OPT has to be directly related to your STEM major. So that's one condition. Another condition is that the employer that you're working with is registered with E-Verify, which is a government program that kind of oversees all of the I-9 records for the employer. And you have to apply while you're in your OPT, your initial 12-month period. If your OPT has already expired and you didn't, file for the STEM extension, unfortunately, you can't go back and get it. And then another note, and this is a really common question that I get a lot, is changing employers while you're on your STEM extension. You can change your employers. Let's say you start with one company and you want to switch to another. You can do that. You have to notify your school, so they should update your records. Anytime there's any change in your employment, obviously, you should always let them know. But the new employer also must be registered in E-Verify, so that's something else to note. And a lot of employers are not registered with E-Verify, but in terms of, all of the immigration reforms that everyone's talking about that you see in the news all the time, I do think that it's a direction that we're all headed in, and I think it's something that employers will be, someday required to be registered with. It's just a matter of time, I think. That's my opinion. But at the same time, sometimes it's difficult for employers because it's additional, it's additional government oversight, so it may not be the most attractive option, but, you should talk to them. Maybe they're open to it. It doesn't cost anything. I mean, it just takes, obviously, they'll have to have someone who runs the program, but it's probably their HR person. I mean, it's their employment records they have to keep track of anyway. It's just, again, it's government oversight. Some additional information about OPT. You have to be careful of unemployment periods, 90 days of unemployment for the regular, the 1 year OPT, and then, no more than 120 days for the STEM OPT. And if you reach those times, then you would be out of status. How to avoid it, obviously try and do an internship or volunteer and just do 20 hours, but it has to be in your field of study. And so you can do that, and you should always keep track of your employment, whether you get a letter. I mean, if you're paid, obviously that's a lot easier, but if it's unpaid, then you should get a letter from the company or the employer, verifying, so-and-so worked here for 20 hours for these, 20 hours a week for these 3 weeks, in March or whatever it is. So you just want to make sure you keep track of it, stay in close contact with your school, obviously, and let them know anytime you have updates in terms of your employment. And then just another note is that there is, once you do the 1 year or, you finish the STEM extension, there's also a 60-day grace period once your OPT ends. This is really for you to kind of, tie up your affairs, but also, visit friends, family, go to Disneyland, that kind of a thing. It's not work authorized during that. You don't have work authorization during that 60-day grace period. So that's, something to also note. But, the expiration date on your OPT card is not the last day you're allowed to be here. You can continue to be here for 60 days. And during that 60-day grace period, you can also file a change of status application. I have a couple of questions here that related to OPT, so I'm just going to look at them quickly and see if there's something that I can talk about now, or we may address it later. Does employment during the OPT extension period have to be paid, or is volunteering fine? It does not have to be paid, obviously, so that's good. But, so, I mean, you should be looking for a paid position, I would think, but obviously that's not always your choice. Does the period of unemployment start from the day you graduate or the date your OPT is effective? It's only once you get your EAD card, the first date that's printed on it. So if it's June 1st, 2013 to June 1st, 2014, you only have to keep track of your unemployment as of June 1st. You can only start working on June 1st anyways. Don't forget to apply, even if you're not planning on getting OPT, or if you plan on going home, or whatever, or if you don't have a job, whatever it is, you should still apply. I always recommend filing for this because you never know what's going to happen. You may have all these plans of leaving, and then life kind of life happens, things change, and maybe you get this really great opportunity, and you want to work. So I would just go ahead and apply. You have to be aware of your program end date. So again, speak with your school. The earliest you can apply is 90 days prior to your program end date, and the latest is 60 days after. So for those of you who don't have a job yet and want to, kind of maximize the amount of time that you have here in F-1 status, you should probably do it closer to the, after your program end date, up to 60 days, So then that gives you an additional 2 months of just, time to be here. You don't get work authorization, but you should always check with your school for exact dates because we've had some issues in the past where, people thought their program end date was one date and really it was another, and they missed the window, and it, kind of becomes a mess. Another reason, I guess, that I should mention is it's kind of a good stepping stone for your H-1B employer, because a lot of times initially when you first start with a company, people feel bad asking for visa sponsorship, or they're not sure what the company policy is. This way, you have work authorization, so you can work for the employer, and then hopefully, if things go well, you like the employer, they like you. At that point, once you've been there for a period of time, then they're more willing or open to have that conversation. So I always recommend it, just in that regard as well, to kind of check out the relationship between the two of you. Okay, so then that's OPT. I think it's pretty straightforward, and I know a lot of you guys have a lot of information, through your schools as well. So make sure, again, to talk to the school about any more specific questions. I'm happy to answer them. So after OPT, what are your options? I know a lot of you guys are listening. I shouldn't, I guess, before we move forward, obviously the H-1B cap has been met. I'm still going to discuss the H-1B visa, because some of you may have applied and been selected, or some of you plan on applying next year. But I keep in mind that obviously the H-1B visa, the cap has been met, so nobody can apply for the rest of the year. So it's done until next April. But for you guys, for general information, after OPT, the the most common visa category is the H-1B professional occupation visa. The job must be one that requires at least a bachelor's degree, so that's what it means: professional occupation, specialty occupation. They interpret it as just the job requires someone with a degree to perform the job. And I give some generic examples here, financial analyst, accountant, computer scientist, software engineer, that type of a position. It's employer specific, so that means, you have the visa, the employer sponsors the H-1B, it's only with that employer. You can't work for two different employers on one visa. And then it can be for part-time or full-time employment, so it's a great option. Obviously, even if they can only sponsor you for part-time employment, it's still good. And if you do have two employers that are interested, you can file concurrent H-1B. So you would have two H-1Bs for two separate positions. There's a 6-year maximum. It's granted in 3-year increments. It's at-will employment, so you can leave at any time, and the employer can terminate you at any time. That's something people ask about all the time. Just because it's granted for a 3-year term, it doesn't mean that you're stuck with that employer or tied to that employer. And portability is a term that we use quite often. It's where you transfer your H-1B to a new employer. You still have to file the whole petition and pay all the fees. They love their fees, but you can file it, and you can actually start working as soon as the petition is filed. You don't have to wait for the approval. So it's something that is in place that makes transitioning to a new employer a little bit easier. So the quota, we'll talk about that, which is, we use interchangeably with it. The cap has been met, the quota. It's conducted for the fiscal year, so October 1st to September 30th. So for anybody who recently filed, you file on April 1st, and it's to start employment on October 1st. So you file it basically 6 months in advance. The cap only applies to private employers, so there are cap-exempt organizations that can file H-1B petitions at any point. There is no maximum, there's no quota or anything, and so I'll discuss that a little bit later. But there are 65,000 per year for a bachelor's, U.S. bachelor's degree, and then there's an additional 20,000 for graduates with a master's or higher, and it has to be you have to have a master's or higher from a U.S. school. How early can you file? The earliest would be April 1st. Obviously, that time has passed, but hopefully this is something, you guys are really on the ball, and you're listening to this, and you're graduating, and you just graduated now, you're on your OPT, and we can file next year. Some timing issues, obviously, this is really relevant right now. Just so you know, for those of you who don't, before we used to have what's called March Madness, where we had this, the lottery to pick the petitions. And then for the last 4 years, basically, the cap, because of the economy, and basically because of the economy, obviously, employers weren't hiring as much or not in the same way, and so the cap stayed, it stayed open for much longer. So the earliest you file is April 1st, and so for 2009, in 2009, for instance, it stayed open from April to December, and all those, all the years prior, they all ran out. The visas ran out the first week. So that's how it's been the last several years, and then all of a sudden this year, there's a typo here, but on April 5th, so it opened on April 1st, and then on April 5th, USCIS announced that the cap was reached, and they conducted a lottery. So it looks like we're back to how things were before, and so basically what happens is everybody files that first week, and we did that, here in our office as well, obviously, and probably across the country, everybody filed. And if USCIS didn't receive your petition by that first week, then obviously you were out of luck. But even if you did, they still conducted a lottery, and I think we just received our final receipt notices, I think up until last week we were receiving them. And, and then those that were not selected, they're out of luck. So their petitions are rejected, the filing fees are returned, and they have to wait or figure out another option and file again next year. Anyway, so this was the shortest H-1B filing season since 2008. And so hopefully it means it's bittersweet because it's good, meaning hopefully the economy is getting better, employers are hiring, they're sponsoring people for H-1B visas, but obviously it's also, it's hard because there are a lot of people who made the application, but because of the sheer numbers alone, their petition was rejected. So this will apply to a lot of you guys, or for all of you, hopefully, cap-gap extension. It applies to all F-1 students. So as long as you timely file your H-1B petition, and I'm assuming, obviously some of you did that this year, and some of you who are doing it next year, as long as you timely file it, then your work authorization, your F-1 status is automatically extended. If you file it before your OPT expires, then your employment authorization is also automatically extended. So it's something that was, kind of put into place to help students basically over the summer months between graduation and October 1st. Because of since it doesn't take effect until October 1st, what happened previously is that people, they couldn't stay here and they couldn't work, and it was just this weird gap. And so basically there's now what's called cap gap. And then just a quick note, if your OPT is extended, it's only extended until October 1st. So if for whatever reason your petition is still pending and it's, October 31st, you have to be taken off of payroll because you don't have work authorization until it's approved. I have a little kind of a little illustration of cap gap relief and how it works. So let's say if you're listening, you graduated last May and your OPT started last June, which was good for 1 year. Hopefully then this year you filed your H-1B petition on April 1st and it was selected. What happens there is that your OPT, even though it's set out, and here's even though it's set to expire June 2013, because of cap gap, because you timely filed it, your work authorization, your status to be here is automatically extended to October 1st, which is really good news. So hopefully, this kind of smooth transition works for you guys, or you're able to take advantage of it. If for some reason if you filed the petition, it wasn't selected, your cap gap relief basically ends upon rejection, denial, revocation, and you have a 60-day grace period from that date. So if any of you applied and were not selected, it doesn't, backdate or anything like that. It just based on whatever that date is. Or if some of you were selected in the lottery, and let's say, you get a request for evidence and you respond, and then it's denied in August, for instance, then as of August, you have a 60-day grace period to leave or to file a change of status. And you can't travel during the cap gap period, so that's something, well, you can, but you can't re-enter on the F-1, so you would have to stay abroad until your H-1B petition is approved, get have your visa interview, and then come in. So that's something also to think about. Quickly, the overview, there are 2 government agencies involved, USCIS, which is U.S. Citizenship and Immigration Services, and Department of Labor, DOL, which is what we call. There are 2 steps. You do the Department of Labor steps first in terms of verifying the employer's tax ID number and the LCA, and then you have that, then you file the second step with USCIS. I just mentioned RFEs, so again, if any of you have recently filed an H-1B petition and you were selected, you have a receipt notice and everything, you may get a request for evidence. They are, fairly common. So it's nothing to be worried about. The things they, come up the most often are whether the position is a specialty occupation. Is it really a job that requires somebody with a degree? And a lot of times, what it's kind of open to interpretation, right? So something in, marketing, for instance, they love to pick on marketing. They may argue that it's not, so you have to, provide evidence that it is. And then another one here, I have Vibe, which is an online system that they have where they verify the employer information, including the address and, what, in terms of how viable the company is. So they just want to know more information about the employer itself. So those are the two most common types of RFEs. Like I mentioned before, there's a 6-year maximum. There's an exception I'll discuss later under AC 21 to continue to extend it beyond that. The cap doesn't apply, so let's say you do the 3 years and then you want to file your extension for the additional 3 years. You don't have to worry about the cap again. It doesn't apply to extensions. There's something called a remainder option, which if, I don't know, some of you maybe had an H-1B before you went to F-1 student status and you didn't use your 6 years, you can actually use that time, and I have a little notes here, so H-1B to F-1 to H-1B, or if you had an H-1B and then left, you still have time that you can use and you don't have to worry about the cap. So maybe that's an option for some of you out there, and you should take advantage of it. For the H-1B, there are some employer obligations. They must pay you the prevailing wage. You can find this information at the website I have here. There's something called no benching. Benching means that they kind of just put you, they say there's not enough work or they can't pay you or whatever, so they tell you to just basically stay home. They can't do that under the LCA attestations and under these rules. But a voluntary leave of absence is fine. Let's say you wanted to take off, a month to go, home to visit family or maternity leave or something like that. That's fine as long as it's at the employee's request, or if somebody's leaving to go study for the bar exam, for instance. That's all fine, but the employer can't do it just because they can't pay you, because there's an obligation to pay you the prevailing wage. If, for whatever reason they're downsizing or they need to terminate you, if they are letting you go, they have to offer you reasonable costs of transportation home, just you, not your family members, and it can't be, home to, India, for instance, by way of Hawaii or the Bahamas. It's a reasonable flight home to your home country, not, to another country. And they are required to notify USCIS and to withdraw the LCA and the petition. Whether or not they do, we don't know. Obviously, if the employer is our client, we always advise them of that, and so they are required to do it. It's just not, they don't always do it, but it is something to keep in mind, because a lot of times people are like, oh, they're not going to say anything, I still have time and I can, figure things out. But there is that requirement in place, so you don't really have that kind of a buffer there. Who is responsible for the fees? That's always a big question. Hopefully in the perfect world, the employer would pay for everything and they would be happy about it. But unfortunately, that's not always the case. With the H-1B, they're really strict. The Department of Labor actually has, regulations about who can pay what and all of those things. There are penalties and fines, civil and criminal, so it's something that you have to, be aware of. And even if, you've heard of people doing certain things, you should stay away from it. But anyways, if you do want to pay part of the fees, you first and foremost, the main rule to remember is that you must still be paid the prevailing wage. And what I mean is that, I have an example here. Let's say, and this is all published on the Department of Labor website, but let's say I look up the prevailing wage for let's say, an accountant in the Los Angeles area, because that's what it's actually categorized by occupation and then, the area in which you'll be working. So let's say prevailing wage in Los Angeles for an accountant is $60,000. Your salary is also $60,000. If that's the case, then there's zero wiggle room. That you can't pay for any of the legal fees or the government filing fees because your salary would actually drop below the prevailing wage. Who will know? I will know, and I'll be very disappointed. I'm kidding. But it could come up at your visa interview. A lot of times at the visa interview, depending on your home country and the consular post, they do ask to see your W-2 or a tax return. So even if it's not this year, it could be next year. Or, if there's some sort of an audit or an unannounced visit, they can find this out in other ways as well. But let's say prevailing wage is $60 and you're being paid $75, then there is a little bit of wiggle room. There are two fees that have to be paid by the employer. It's the fraud fee, which is $500, and the training fee, the acquia fee, is also another term for that one. So those two have to be paid by the employer. The training fee only applies to private employers. The fraud fee everyone has to pay. And then there are no reimbursements. I write that here too. You can't work it out with your employer that they pay the fees and then you repay them, or that they take it out of your paycheck, or that that you write a personal check or something like that. No reimbursements. But the other government filing fees can be paid by you or your employer. Again, as long as you're earning above the prevailing wage, you can pay the I-129 fee and the premium processing fee, and you could also pay the legal fees, again, as long as you're being paid above the prevailing wage. So I mentioned audits and enforcement. I mean, there has been such a huge increase, and I think it's only going to get, it's only going to increase from here. In terms of fraud investigations and unannounced worksite visits, I have clients all the time who tell me that they had somebody stop by, and basically it was somebody from ICE or FDNS, which is the Fraud Detection and National Security Task Force, where an agent shows up, asks to speak with you, or asks to speak with your supervisor, or they look for the person who signed the petition. A lot of times it's the CEO or something. They ask to speak with them. They ask, they just basically want to make sure that you are doing what we said you were doing in the petition, and that you're being paid the prevailing wage. They can ask to see payroll records and all of that. So it's definitely something that we're seeing a lot of across the board in all sorts of companies. It's not just small companies, large companies, and everything else. So it's something, and that's one of the main reasons why we definitely make sure that you're aware of it. A lot of times the employer may or may not care, but you should also be aware of it because it puts you and your status in jeopardy. The prevailing wage is one of the bigger issues. I'm actually involved in an audit, and that's the one, that's what they're looking at the most, is the prevailing wage issue. For those of you who have families, there is, for the H-1B, there are H-4 visas for the spouses and children. It doesn't allow, or it doesn't provide work authorization, but it allows your family members to be here. It gives them status to be in the U.S. They can go to school while on these visas. But if you do have a spouse that wants to work, she or he would have to apply for their own visas. In terms of the 6 years, let's say, hopefully, you were on your OPT, you were selected for the H-1B, and you're going to have in the lottery you were selected, you're going to have 6 years. After the 6 years, there are just a couple of notes to make, beyond that as you're looking forward. You can recapture all of your time spent abroad during the 6 years. So let's say every summer you and your family, you travel back home for a month or 2 months, whatever it is. Those 2 months over 6 years could, obviously add up to be about a year's worth of time that you can recapture. It doesn't just have to be trips home. It can be trips, any trips outside of the country. So even if you go to Canada or Mexico, or if you go to Europe or vacation, wherever it is, you can actually recapture that time, which becomes very valuable down the road when you're looking at green card options. So something to keep track of through, flight itineraries, or, if you want to make a little chart or something. And then there's also another, you can also extend your H-1B beyond the 6 years, and I had mentioned AC-21 earlier. It's something that's in place for, people who have started their green card applications, and they're at one of two stages, which I have, written here without getting too technical. But you can either extend your H-1B in 1 year increments or 3 years, depending on the stage in which your application is. Just some myths, some of the top 10 myths about the H-1B visa. I'll just mention a few. You can still do H-1Bs for small companies and for startups. What they're mostly concerned about is the viability of the company. So let's say it's a small company or a startup, and there's only a few employees, but it's got strong financial backing. And let's say you can show that there was an initial investment of $2 million or something like that, then that's definitely a viable company. Or if you can show a strong business plan, or something like that. So startups are okay. It's just you want to be able to show the backing, because they want to know that there's enough money to cover operational costs, overhead, as well as their favorite, that you're being paid the prevailing wage. That's like their number one concern, and it's one of the attestations, again, that the employer is making. So anyway, startups are okay. There's no advertising requirement. That's a requirement that they have with the perm, with the green card, and where you have the Sunday ads and all that. It is something that they're discussing. Again, if you've been listening to the news in terms of the immigration reform, they are talking about adding an advertising requirement to the H-1B visa category, which would obviously be additional costs, and it's cumbersome and all of those things. But as of right now, it's not something that has been a part of it. There's a posting requirement, which is they just have to post something internally, in the kitchen on the bulletin board or something like that. But there's no advertising. You can change employers, which I mentioned. Another huge one is this grace period. There is no grace period after a layoff, or even let's say you quit, thinking that maybe there's a grace period. There's no grace period. So if if you're let go tomorrow, then tomorrow's your last day, and technically you are required. You're supposed to leave the country as soon as possible, or file a change of employer. Obviously, that day or the next day, if possible. You can go to school part-time on the H-1B, so that's good for those of you who want to go to night school, or if you just finished your bachelor's, you want to do, like a master's at night or something like that, you can do that. In terms of filing, you want to file under the master's cap, which I had mentioned earlier, the 20,000 extra visas. You actually have to have that degree before you can file. So the timing of it is a little funny because of, you have to file on April 1st. I don't know very many people, unless you graduate in December, the year, December of a few months before, you're not going to have your degree or have finished your degree requirements on April 1st, so you can't file under the master's cap. You'd have to file under the bachelor's cap, or wait, until the next year, I guess. But the other premium processing, this is one that I don't know. Maybe it does. Well, it might increase your chances of getting a receipt. I noticed all of my premium, and I shouldn't say this. This is, again, my experience. This is not, by any means anything. This is kind of like a total random guess. But all of my premium processing cap cases did get receipt notices. So they were all selected. I don't know if it's because, I don't know why. I don't know if it was just a coincidence or what it was. But that doesn't mean they'll be approved. So that's something to note in terms of the lottery. I mean, they still adjudicate each petition, at least they're supposed to. So I don't think it makes it any worse. In fact, all it does is it adds like a time pressure. So sometimes we'll get requests for evidence in premium processing cases where we wouldn't in regular. And anyways, these are all guesses, and everybody's experience is different. I'm just giving you a little slice of what I'm thinking right now, and it changes every week. But and I guess one of the other quick points I'll make is that you have to have a U.S. degree to qualify for the H-1B, and that's not true either. It just so happens a lot of times people do. But if, let's say you're in a master's program, but you have a foreign degree, your bachelor's degree, you earned it in Japan or something, and you're here in the master's, and you want to file on April 1st, you don't have your master's degree for the master's cap, but you can still file under the bachelor's cap with your foreign degree. You just have to have it evaluated. Okay, so, and now this is, probably a question a lot of you have. I hope you don't. I hope all of you guys are filing next year. But if some of you missed the lottery, let's say the cap has been met, now what? What are some other options? Some options that you have, aside from the standard H-1B visa, is to get an H-1B with a cap-exempt organization. That means that the employer is not subject to the cap and can file any time, today, tomorrow, and every day. They can apply. There's no limit or quota, but a cap-exempt organization is only one of the 4 listed here. So it's an institute of higher education, a nonprofit affiliated with an institute of higher education, a nonprofit research organization. Note, it's not a nonprofit organization. It's a nonprofit research organization or a government research organization. So, it may seem broad, but it's pretty specific, but it may be a good option for any of you who want to, teach or do research or something like that at a university, which, that's always a good option. And then some other options would be, well, this isn't an option, but if you went from a cap, and just a note in terms of cap exempt, but if you go, let's say you do this, let's say you get a job teaching at, UCLA or something, you just finished your doctorate and you're going to teach there, then they can file for an H-1B and you can work for them, but then next year you get a job in, working at IBM. At that point next year, then you would be subject to the cap because, basically you've never been counted. So even though you are on an H-1B already, you would have to file on April 1st next year and be counted, basically, with your new employer. Some other options are the free trade agreement visas. These are very similar to the H-1B. And it's not the H-1B, but they're similar in that they are, it has to be a professional occupation, and there's a degree requirement. So for Chileans and Singaporeans, there's the H-1B1. And there are still H-1B1s there's always, visas available for those too. There's the TN visa, which is for Canadians and Mexicans. It's the NAFTA visa. And they're very specific. There's a TN appendix list. The list of occupations is much, much more specific than the H-1B, so you definitely have to check to make sure that the job for which you're applying is on that list. And just a couple quick notes. Canadians can apply at the point of entry. So that means, if you're coming in through, you can either drive through, if you drive through Buffalo or something, you apply, you just actually hand over the application to the CBP officer. He reviews it and approves it, and you just come in. Because Canadians are visa exempt. There's no consulate or anything. And then for Mexican nationals, you would apply for it directly at the embassy in Mexico. You can also apply for these, internally, but that just means government filing fees. So that's the TN, which is really handy for Canadians and Mexicans. And then there's the E3 visa for Australians, and very similar, again, professional occupation, There's a prevailing wage. The TN does not have a prevailing wage, by the way. I didn't mention that, but the E3 does have a prevailing wage because they have an LCA. And for the first one, Australians have to apply directly at the consulate abroad, and beyond that, you can extend it here in the U.S., and the E3 is 2-year increments. So that's just something very specific. I don't know, it depends on your passport, but these may apply for you as well. Another good option, which I'm recommending to some people who missed the cap, also is the J1. It's for exchange visitors. It's a short, it's kind of a Band-Aid, it's a short-term solution, and really the purpose is for cultural exchange, and it's for interns, trainees, or professor, research scholars, or teachers. And they're split up in terms of the categories. A trainee is for 12 or 18 months maximum, cannot be extended, and you have to have either a degree in 1 year of experience or 5 years of experience outside the U.S. And it's limited to 12 months if it's in the hospitality or tourism industries. Then there's the intern category, which is for a maximum of 12 months and also cannot be extended. You have to either be currently enrolled at a foreign degree, like a school outside the U.S., so this doesn't apply to all of you who are here, or who have graduated from a foreign institution no more than 12 months. So basically, you have to be a recent graduate with, from a foreign school to qualify under the intern. So trainee or intern. And then foreign teachers, for anybody who's listening who's a teacher, if you are qualified in your home country and have 3 years of experience, you can be sponsored by a school here in the U.S., an accredited school, to teach here in K through 12. So, and there's a 3-year maximum on that. So that is a great option as well for anybody who's interested in teaching, the J1. So this is the one instance, it's 3 years. And again, I wrote here, it cannot be extended. That's probably the most common question I get about J1s is, what do I do now? Can it be extended? And it cannot be extended. There's also the J1 for professors and research scholars. They're for university and research positions. It's a short-term scholar or academic appointments, and that's sponsored directly through the school. And then one quick note, I write beware. Anytime somebody says they're on a J1 or that they're thinking about it, some foreign nationals are subject to what's called a 2-year home residency requirement. And what that means is that you're, basically if you are subject, then you have to go home and meet this 2-year home residency requirement. So that means you have to go home and establish, show that you're home in your home country for 2 years. And you can apply for a waiver, and there are different waivers you can apply for, but it's something to be very, very mindful of. It will be checked or marked on your DS 2019, which is the form you get, and it should also be annotated on your J1 visa in your passport. So if you are subject, you would know. And then similar to the F-1 is there is a grace period at the end of the J1, but it's a 30-day grace period. It's not 60 days. So, even though your J1 program is ending, you do have a 30-day grace period, during which you can be here and do whatever, or you can do, file a, change of status or, figure out what you want to do. Similar to the J1, there's an H3 trainee visa, and it's a petition that you file through immigration. The J1 is done through sponsoring companies here in the U.S., and they're designated by the State Department. They actually pretty much process all of the paperwork, send it to, and basically give it to the foreign national. So it's done a little bit differently. The H3 is similar to all the other visa options where you file through a USCIS. Anyways, it's also training. You have to show that it's not available in your home country and that it will benefit your career abroad. It shouldn't be productive employment. It should really be about training, and there should be a training plan and a training program. and that you have to show that you have a residence and a job abroad once you're done with the training. The one that's really difficult is training not available in home country, because a lot of, that it's difficult. It's doable, but it's difficult. Or it's a challenge, I guess, for me. Okay, some other options, probably more geared towards business and entrepreneurs. There is the L visa, so there's an L1A and an L1B. For either, L1A is multinational, executive, or manager. L1B is specialized knowledge. Basically, this is for companies, larger companies that have an office abroad, or offices, even better, multiple abroad, and then also an office in the U.S. And basically, the idea is that you have worked for the company abroad for at least 1 year, and they want to transfer you to the U.S. So for some of you who are graduating, or who have graduated, or you weren't selected in the lottery, there is a large company that's interested in employing you, but since there are no visa options, what you could possibly do is, that they have an office in, London or Shanghai or, wherever. You can request and say, I would love to work at your offices, abroad. You can go and work there for at least 1 year, but multiple, who knows, which is what happens. Maybe you'll like it. But you can do that, maybe work for them abroad, and then assuming you'd be coming in as a manager or executive, you could come back in. They could transfer you from abroad to the offices here in the U.S. To work here. So that could be an option for some people with some offers with larger companies. The L1B, the specialized knowledge, that is if you really have, and specialized knowledge is not just like, the way that they describe it is that you can't easily, train somebody in 6 months to know what you know. So if they can be trained within 6 months to do what you do, then that wouldn't be considered specialized. And, you can say proprietary. So in certain technical fields, this applies. Maybe you can get really creative. Maybe a certain sales technique, that only a certain, special team knows about. There's all sorts of ways of figuring it out. But those are the two options, and it's a really great option, actually. So if you are working for a larger company, you should think about this. And last point is, the corporate relationship of the company abroad to the U.S., there has to be some sort of relationship. So whether it's parent, subsidiary, or if they're both affiliates, or something like that, or they share common ownership, that must be demonstrated as one of the requirements as well. There is such a thing as a new Office L. It's only good for 1 year. So let's say you work for a company abroad and they're interested in opening a new office in the U.S. So let's say you work there for several years, you're doing well, you're a manager, or you have in the past. It has to be one year of the immediately preceding 3 years that you've worked for this company, so it has to be pretty recent. But you work for the company and they want to send you to the U.S. to open up a U.S. office. You can do that under a new Office L. They're a little difficult because you have to show how strong the company abroad is. That X amount, certain money has been transferred to the U.S. You get office space. You buy computers or inventory or whatever it is, that's related to your business. You set everything up, the bank account, everything, and then you apply. And it's only good for 1 year. At the end of the year, you have to show, hopefully, that the company has grown. You have clients. You've hired some U.S. workers, that kind of a thing. But it's a great option if again, for companies that don't have a U.S. presence yet. There is a maximum of 7 years for the L1A and 5 years for the L1B. The good part about the L visa is that the spouses and children, you get the L2, but the spouses get a work permit. It's for unrestricted employment that they would apply for once they're here in the U.S., they can actually get, it's very similar to the EAD. In fact, it looks exactly like that. So they would have employment authorization. So it's really great. And then the other good point about the L is that there is an EB-13 green card, which is basically the green card version of the L, where you're demonstrating, you're showing all the company documents and the relationship between the foreign entity in the U.S. and your managerial role and all of those things. So it's a good basis for a green card as well. This is one of my favorites, actually, of the visa options. But again, it's very, business related. Another good business entrepreneur option is the E1, E2 visa. It's for treaty trade and it's a treaty trade and treaty investor visa. There has to be a treaty between the U.S. and your your country of citizenship, and you can check the treaty country list at travel.state.gov and to make sure it's there. If it's not, then this is not a visa option for you. But if it is, then this is a great option. You can do either as a trade company or as an investor, and at least half of the company has to be owned by someone from your treaty country. So that's something important to keep in mind. And you can start up your own company, or you can buy a company as an E1 or an E2. I can give you some examples. For instance, in terms of starting up, you can set up your own company, or you want to buy, you can buy a Quiznos or something like that in terms of how that works. The treaty trader, at least half of the trade must be between the treaty country and the U.S. So this is, an import-export business. This is the E1. It would apply. If you want to be basically just to be an investor or to buy a business or to set up your own business or to run it, you have to show, there are a couple things, but you have to show substantial investment, and substantial is their term. It's not ours, and it's not very specific. But, substantial, we're talking, $150,000, $200,000 at least would be substantial. And it's not just money sitting in a bank account. You actually have to invest the money, again, get the office space or the lease. Let's say you're, setting up a clothing, like in a clothing store or something. You have to buy the inventory, buy all the shirts and the pants and the hangers, and set everything up, a cash register, hire some employees. I actually, would like to see that you've hired some people and all of those things. And then you would be coming, as the principal investor, and also, to be either, to run the company basically, to be the investor and, manager, and you would have to show that you have a background in business. So if you have never run a company, but you're coming here to run a company, you may run into problems at the consulate when they're interviewing you, because you should also be, you would have to demonstrate that you're qualified to do this, because they don't want it just to be, like I'm really wealthy and I'm just going to, do this just to get a visa. So, you would have to show all of that and convince the officer. Spouses and kids receive dependent visas, and again, similar to the L, spouses can also get a work permit, and it's unrestricted. So this is also a great option. In terms of the application, it's actually, the initial one is put together, and you file it with the consulate in your home country. They take anywhere from 1 to 3 months basically to review the application, the business plan, evidence that the money's been spent and all of those things, and then they schedule you for an interview, and at that point they ask you questions, make sure you're, that you are, qualified to run this business, and then you come in. It's a 5-year visa. It could be 2 years or 5 years, actually, depending on the strength of the business plan. Another option for some of you may be the O1 visa. For those of you who are maybe established in your careers in your home countries, and then you came to the U.S. and went to school, and you're kind of starting your career, starting your career in the U.S. but are already established abroad, this may be a good option. It's separated into two classifications, O1A and O1B. O1A is science, education, business, or athletics. O1B is arts or motion picture TV. Motion picture TV is self-explanatory, but arts includes, artists, musicians, visual effects artists, graphic designers, and if you're an advertising, like a creative director, an art director, sound engineers, those kinds of those fields. So it's a really nice option if you're in those, or again, O1A is self-explanatory as well. But O2 visas for essential support and O3 visas for dependents, but there's no work authorization for the O1. There are standards that have to be addressed in your evidence for these various categories. O1A is has the highest criteria, highest standard, and you have to show that you are one of a small percentage at the top of your field. O1B is a little bit less. I know it's kind of, you say tomato, I say tomato, but it really actually is different. So O1A, small percentage. O1B is just high level of achievement, substantially above that ordinarily encountered. And then O1B is even a little bit lower for film and TV. It's high level of accomplishment. So again, it may seem small, but there are actually pretty big differences. Types of evidence would, this is for, for example, I will use I'll say scientist. For example, these are just some that are, some examples, but so it varies by industry or field or position, really. But if you're a scientist, and the easiest would be, if you've won a Nobel Prize, for instance, that's actually a one-time achievement, which is all you would need. But if you've been nominated for some prizes, if you're a member of a very elite group, or if you've, obviously, if you're a scientist, hopefully you've published a lot in some major journals, and your citation record is high, and you've been invited to, review papers for a journal, or to be a judge, or you have a patent and it's being used by NASA. There are all sorts of things. So that's specific to scientists. But if you're a business person, maybe you've had some articles written about you and your success. You've been invited to speak or be a keynote speaker, or you receive a really high salary. All sorts of things. It just really, the evidence varies by occupation. But the O1 is good, but really it's for those of you who have reached a pretty high level in your field. And again, it can be abroad, here, actually the more international the better, but it doesn't have to all have been here. Just some quick, in terms of job search tips, obviously the internet, social networking sites, your school career services offices, I think, are particularly useful. Placement agencies, I know a lot of people who have had a lot of luck going through placement agencies, or your local chamber of commerce, or if your local embassy or consulate. A lot of times, people who have naturalized and become U.S. citizens, they stay in close contact with their consulates or embassy, especially if you're a tight-knit community, and they may, go there to post jobs because they want to hire people that have, similar backgrounds, culture, language. You never know. You might as well. You should check. And some arguments I always make, or to keep in mind, maybe when you're interviewing or just talking to employers, is that I would highlight your international perspective, and talk about how in this economy, basically it's a global economy, and cultural diversity. Having foreign talent places them at a competitive advantage. These are the types of things that I think is true, and you should definitely highlight. Okay, so I just ran through basically all of the major visa categories that I think, would apply or may apply to you. Obviously, there may be some that, for instance, I'm just going to say, like there's an I visa for foreign media, basically for journalists. So if you're, a writer, for instance, and you want to, be a or you are a journalist, and a a newspaper in Austria, or several, for instance, want to buy your stories, then you could be here on an I visa, for example. I mean, it's definitely a little bit more complicated than that, but that's another option. So there are some more specific visa options. The best way for me to tell you is for you to send me your resume, and I can try to see if I can help. This next portion of the presentation is going to be about green card options. So without further ado, we'll move on to that. There's the green card lottery. I don't know if anybody who is listening was actually selected in the green card lottery. The letters have been coming out over the last several months. I'm sorry, the last several days. We've been getting lots of emails actually within the last week or so. So if you've been selected, congratulations. That's great news. If you need help with the second step, feel free to contact me, and we can help with that, whether you want to process abroad or you want to adjust your status and file here. I can help you with that. For those of you who don't know what in the world I'm talking about, there's something called the Green Card Lottery. And again, you can go to travel.state.gov and you apply directly through there. It's closed right now. It's literally what it is, what I just called it, Green Card Lottery. They give out 50,000 green cards every year. There's a registration period. Usually it's from like October 4th to November 4th. It's a 1-month period, always during that time. And you can register. It's very simple and easy to do on your own. We can certainly assist with it if you do need help, but it's also something you can do. And there are lots of websites out there who will, basically take money, and I think they're fake websites, and they'll take your money and then say that you've won, but you haven't. So it has to be travel.state.gov that you register through. There's no application fee, and then the only other requirement is that you have to be eligible to participate, which means you have to be from a specific list of countries. So it's based on your country of birth, not citizenship, which is also a little confusing for people, but there are certain countries that are not eligible, and I've listed them here. They're also listed on the website. They actually, sometimes certain countries are added or taken off depending. So something to check out. And then if maybe you're not eligible, but your spouse is, you can both apply. You can cross-charge is what it's called. You can apply based on your spouse's country of birth. I urge everybody, assuming they keep it, again, this is one of the things that may be cut out or, kind of compromised in the immigration reforms. So if it's still left and you are eligible, I urge you to register and apply. And again, it'll be in October of this year, so if you can, please remember to do it. And you never know, you may be selected. We get calls all the time and people are selected. I actually see somebody here on the question. Somebody just said they were selected, so congratulations. Okay, so green card lottery aside, then there are two major categories of green cards. There's the family-based option, and then there is also employment-based. Family-based is pretty self-explanatory. There are really long wait times unless you are an immediate relative of a U.S. citizen, meaning spouse, parent, or minor child of a U.S. citizen. There are going to be much longer wait times, but if you're an immediate relative, usually within about, you get immediate benefits, you get work and travel authorization, 6 to 8 month processing. That can actually, it can be slightly less, or it can, it could be about a year. So that's, but at most. And then something to keep note of is if you marry a U.S. citizen, and you file, and you've been married for less than 2 years when you file, you only get a 2-year conditional green card, and then you have to file another step before you get the full 10-year green card. Under the family-based category, you know, an adult is 21. So in order to, and this is another common question people have, if they have a child that's a U.S. citizen, if they were here and they want their child to sponsor them, they can, but your child has to be 21 by the time they can sponsor you. So if somebody, you know, usually if you have like a 2-year-old, you have to wait until that 2-year-old is 21 before they can file an application for you. I've listed some of the backlogs here. This the visa bulletin, you know, is updated every month. I don't know if this is the most recent. I think I updated this last month, but this should give you a general idea of how long the wait times are for the different categories, and they're based on the relationship of, you know, so unmarried adult children, so meaning like, you know, if you're over 21 of U.S. citizens, you know, 7-year. If you're a spouse of a green card holder, that's a legal permanent resident, or LPR is a green card holder. So that there's a 2-3-year backlog there. Unmarried adult children of a green card holder, married adult children of U.S. citizens. So if your parents are adult citizens and you're over 21. And then brothers and sisters of U.S. citizens, that has the longest wait time, and that's actually another one of the things, you know, that's on the list of reforms to be made that may be compromised as well. They may be getting rid of that one, brothers and sisters of U.S. citizens. And like I said before, you can go to travel.state.gov. That's the magic website. But the visa bulletin is published there, and it's updated every month. So if you'd like to, you know, have a look at it, you should go there and see, you know, which category you fall under, what the current processing times are. Okay, so that's family-based. And then there's employment-based, and the way we, you know, you'll hear about it is EB1 through EB5. So it is EB meaning employment-based, and then 1, 2, 3, 4, 5. So there are different categories. EB1 being is EB1, EB2, EB3 are the main categories. EB1 is the fastest. It's first preference, and this is where your aliens of extraordinary ability, outstanding researchers, professors, and that. When I was talking about the L, the multinational executives and managers green card option, the EB13, these are the, you know, people who have done really well. So when I was discussing the O1, you know, in terms of extraordinary ability, you have to demonstrate or show that type of evidence for these categories. So, you know, something to shoot for, and they have quick processing times. And they can, the EB1 category, EB11, can be self-sponsored. So this is also a very attractive category for a lot of people because you don't have to have, even though it says employment-based, it's employment-based meaning it's based on your achievements, but it does not have to be sponsored by an employer, so that's nice. The outstanding researchers, professors, and the executives and managers do. EB2 is second preference, so that's the next category down, which is where a lot of you may fall under, and EB3 is the third preference. These two categories, there are several, you know, things that fall under. In the EB2 category, that would be, you know, there's the advanced degree holders where you know, you file the perm and you do the recruitment. There's also something else called Schedule A Group 2, Schedule A Group 2, aliens of exceptional ability in art sciences or performing arts. And then there's the national interest waiver, also falling under the EB2 category, which based on the visa bulletin has quicker processing times than the EB3 category. EB3 is third preference. It's a little bit, you know, it's the next one. And this is for professionals with a bachelor's or for an equivalent, or for skilled workers and then other workers. So EB3 is probably the largest category, has the longest wait times and backlogs. When you hear about, when you hear stories about people who've been waiting, you know, 7, 8 years, they're usually in the EB3 category. So for the perm-based green card process, which is the most common, basically your F-1, and then you have your OPT, and then you do your, whatever your visa. Your next step would be whether it's the H-1B or the O-1, and then beyond that, if self-sponsoring isn't an option and your employer is willing to sponsor, you would go through this process, which is the perm-based. So the first thing is the labor certification, and this is where your employer basically advertises for your job. They have to conduct good faith recruitment, show there are no qualified U.S. workers. Assuming they can, do that, then the next step is the I-140, and then the third step is the I-485. Depending on, and then the third step is where everyone wants to be, because once you file that, you get work and travel authorization, so then you no longer need, although we recommend you maintain your, your underlying status, your non-immigrant visa, so your H-1B or your O, it's not necessarily required. But the second and third steps, you want to be able to file together, really just that third step. And the visa bulletin that I was talking about, the backlogs, this is where the backlogs come into play. So I'll show you. This is actually based on the March visa bulletin. So, May has obviously, it'll be slightly different, but not too different. All of the C's listed on this chart, I see. So you'll see on the left, it's employment-based, and then 1, 2, 3, first, second, third, so EB1, EB2, EB3. And then the C's all mean current. So that means you can file steps 2 and 3 together. You can file all of it, actually, together. And so for current, EB1 and EB2 are current for all countries except for EB2, China and India are backlogged, even in the EB2 category. So for Chinese nationals, that is about a 5-year wait time, and for India, it is about a 9-year wait time. And then it's current for the other countries. And then EB3, as you can see, there's a really big backlog. And hopefully, again, with the immigration reforms, they'll fix this so that it's not so backlogged and people aren't waiting for so long. But going back to the H-1B, what I talked about, the AC-21, for people in the EB3 category, you hopefully, as long as everything was filed in the, timely, you can continue to extend your H-1B while you're waiting. So that's always a good thing. But basically, until you're current, you can't file that third step, the adjustment of status, which is where you get the work and travel authorization. And so that's probably the biggest problem for a lot of people. Some issues, deciding between the two, it's not about what you're, it's not about the degree that you have. It's about the minimum requirements for the job. So if you are a project manager, like a software engineer, project manager, and you happen to have a master's degree and 10 years of experience, then that doesn't automatically put you in the EB2 category. It's when we talk to HR, if they say the minimum requirements, somebody in your job or somebody in your position, it could be done with just a bachelor's degree and 4 years of experience, then it would fall under, it would be bachelor's plus 4 years of experience. It would fall under the EB3 category, even though you have a master's and 10 years of experience, for instance, to be in the EB2 category. So that's also, people always confuse that. Some tricks that don't work, adding a foreign language requirement just because you speak that language, that doesn't work. If you work for a translation company, then, yes, language is obviously a part of the position, but you can't impose, extraneous requirements because it's very obvious, and audits, they're very, very common now, so you would be caught. Usually you can't use the experience gained with that particular employer if it's the same position. If it's at least 50% different, like if it's a totally different position, then you could use some of that experience possibly, but it all really depends. I don't recommend using unauthorized employment. Obviously, people do it, I think. And usually I recommend people, obviously you can start the green card process if you started yesterday and they want to start it tomorrow. You can do that. It's just kind of rare that an employer would want to do that. So that's why. But the latest we usually recommend is usually in your 4th year of your H-1B time, wherever you are. That's when we recommend that you hopefully get started, or hopefully an employer is thinking about it or doing, starting the process for you. And you want to make sure you like your employer and vice versa, because, depending on your category and all of those things, you may be there for a little while. Some other quick options. I think we're running over. I just realized the time. There's the EB-4 religious worker green card option, EB-5. That's, for those of you with wealthy friends, family, and you have money to invest, or entrepreneurs. There's $1 million green card and a $500,000 one. There are more requirements than what I'm saying, obviously, but that's for those of you who have, money and you can invest. We can show where the money came from. It came from a lawful source, and what you're doing is creating jobs. The EB-5, the regional center, we do a lot of those. In fact, Mr. Wolfstorf, specializes in EB-5. So if anybody's interested in that, feel free to contact us as well. So I apologize for running a couple of minutes over. I didn't have a chance to get to all of your questions. I have a long list of questions here. What I'll do is I'll print them out, and I will get back to you guys individually. And if you would like, afterwards, you can feel free to email me. My email address is on the PowerPoint and the slideshow. It's f.whittenburg@wolfstorf.com. You can also find my bio and contact information on our website, www.wolfstorf.com. You can, if you're either in New York or in Los Angeles, you would like to schedule an appointment, feel free to call. And you can sign up for our newsletters and updates through our website. And that's it. I appreciate you guys listening, and I hope to hear from you soon. Best of luck.